Can you get divorced without going to court? My name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. Well, the short answer to the question, can you get divorced without going to court, is no, you cannot. In some way, somebody's going to have to go to court. Might be virtual, might be by Zoom, might be a question of filing documents with the court, but the court's going to be involved to some degree. Now, I think when people generally say, can I get divorced without going to court? I think they are really saying, can I get divorced without the need to take the stand, present evidence, give testimony, present exhibits, go through a trial? And if that's what you mean, if that's what's meant by that question, the answer is yes. I will tell you that the vast majority of cases are resolved without the benefit of having to actually take the divorce to trial. But you have to understand, a lot goes into the resolution of those cases. And I think the statistics are that 97% of them do not go to trial. So most of them are done from start to finish without the need to the calling of witnesses and having the actual trial. Now, having said that, there are some circumstances where one must go to court. If there are disputes regarding the custody of a child, the court's going to want to take some testimony, so you're going to have to go to court for that. So clearly there are circumstances, but I will tell you the kinds of cases where the court time is limited is cases where perhaps there are no children, or cases where there are very little in the way of assets, where somebody files a complaint and the parties basically agree how to do stuff. Then perhaps the one who filed will have to ultimately finalize with the court, but the other person might not have to go at all. Cases where there is a default, meaning where one person files and the other person doesn't do anything. The other person, perhaps because they feel that they agree on everything, that there's nothing to fight about, parties have accumulated no assets and no debts, so there's really nothing to contest. Cases like that ultimately will go in the way of a default, which means the one who filed it, they may have some court obligations, but the recipient, not. So is it possible that if you're on the recipient of a case with no assets and no children and no liabilities that you won't have to show up at all? Yeah, it is possible, but that's a very small percentage of cases. In most cases, there's something to fight about. There's assets, there's children, there's, at the very least, if there's no assets, there's debts that have to be, allocated. And so for that, it's likely that in most cases, there will be some limited court involvement, no matter how you slice it. If you have any questions about your situation, or you want to talk to us and see how we can help you out, of course, give us a buzz and we'll be glad to do so.